All right, so I'm going to jump ahead. I think we talked enough about this stuff, and I think you've grasped all the basic concepts in terms of legal jeopardy. Put yourself in. I mean, really the most important lesson is to understand this concept of standard of care, and everything else flows from it. What I'm going to turn to now is, if you so choose to do, what it is about being an expert witness, how you can start doing that, how you can build a successful practice. And really, it's like any business enterprise, filling the market with something that's missing right now. And where would you fall in? Now, I will tell you this. Of the cases that come across my lap, they actually tend to segregate out. Not all of them, and you have to separate out, right? The most common thing we do are cabbages and valves. Those are not actually the bulk of the cases that I see. What would you think are the cases that I see? What kind of cases?
VADS, ECMO.
VADS, ECMO, aortic dissection, circ arrest. Okay? The ones that already have a high associated mortality morbidity, remember, a lot of the times patients get these huge bills after the hospital, and what do? You got someone who died, let's say, and the family is now stuck with this bill. They don't have very many alternatives. And one of the motivating factors is some of them say, hey, let's try to sue and see if I can recover some of the money to pay for this. Or they're angry, or they're upset. There's a whole variety of things that go into the mix. I will tell you this. I used to be taught, everybody goes to these lectures about how to avoid a malpractice suit. All you got to do is be nice and friendly and explain everything. That's not the case, okay? A lot of times, it's really sometimes serendipitous. And it depends a lot on the personality of the family members themselves. We've all come across some very difficult families. And you already can get a sense of the dissension that's already about it. And God forbid anything goes wrong, that's the ones who end up being very litigious. You could almost guess. Sometimes you're surprised. It comes out of nowhere. And usually when that's the case, it's usually some attorney. They've got an attorney put up an advertisement somewhere saying, have you ever been on the heart-lung machine and got an infection? Right? I mean, that's what they do. So anyway, let's switch speed. I'm going to talk a little bit about where, if you want it to be enterprising enough, this can be very lucrative and at the same time do a good thing. And that's the latter part I really want to emphasize, because expert witnessing gets a very bad rap, and it's because there are guys out there who give it a bad rap because they don't understand the concepts we spoke about today, and people end up getting the short end of the stick wrongly. Okay? All you need is to have an expert witness who either intentionally, because they're getting paid, says something against you that's wrong, or unintentionally doesn't know what the standard of care is, but says that he knows. Okay, so this is the gist of what we're going to talk about now. So, of course, as everything is about what we do gets more and more complex, there's a lot of information asymmetry, and that breeds discontent. Okay? We're all rush. Although it's very convenient for me, I think it's a bad thing, the hospitals that have policies that the nurses can get the consent signed. Because you as a surgeon, that's the really only documentation you have that you got the consent. You need to write a note in the chart and document everything. And it needs to, I've moved to doing things that are more or less standardized. Because where you get hit is the things that you don't discuss, or the patient claims that you did something you weren't supposed to do and you didn't get the consent for it. We all know, right? With cardiac surgery, usually on my consent says coronary artery bypass, and have another clause about and address any other issues that come up during the course of the operation, right? If I'm a cardiac surgeon and I'm going to get to this in a second. If I'm a cardiac surgeon and I'm doing a cabbage, and of course it never happens, but the TTE didn't show any valve problem pre-op, but now we got a TEE that shows significant AS that I've got to address. Do you think that's something that I can do without talking to the family? You can, but advisable not to, okay? get either you scrub out or you send somebody to go do it. You wouldn't tell, I mean, for me, I never tell a patient's family how many grafts I'm going to do. That's just asking for trouble, because you know how much we change the course once we get in the operating room. But the more disclosure, the better. And we have to be very careful, because even if it says so in the consent, you come out with a surprise. It's amazing the reactions. If everything goes well, nobody says a thing. It all hinges on damages, again, any untoward outcome. All right, let's move into this topic area. Your role, your most important role, is to help the attorney, the judge, or the jury, or the jury understand the evidence in the case. That's your primary objective, above all else. It's not to help your attorney win the case. That separates the good from the bad and the ugly, okay? Your job is to be honest, very analytical, asking yourself, putting yourself in that situation. Could this have happened to me? And if it happened to me, would I have done anything wrong? All right, and that usually will steer you in the right direction. Expert witnesses date back to, boy, almost the start of our country. 1767, the first documented use of an expert witness. This was Slater versus Baker and Stapleton. Slater filed an action against the surgeon and the apothecary, you can tell how old this is, for improper management of leg fracture. A lot of the stuff that was in the early days was orthopedic, so that really was the only, right? If you're going to do malpractice, it was mostly around surgical procedures, because the patient can point to something. If you give them the wrong medication, you know, it's very hard to ascribe, liability for that. But if an orthopedic surgeon didn't correctly set an arm or made one leg shorter, that's very obvious, and that's what usually a lot of the bulk of the cases were in the early days. Slater produced the physician witnesses who testified that the defendants failed to follow standard medical practice. And there the judge said doctors should be judged by the rule of the profession. And this set the stage of medical expert witnessing for cases, because before that, nobody understood what anybody was talking about. Moving on to one side. So Melvin Belli, has anybody ever heard of this guy? All right, this guy is one of the most litigious attorneys. He's a little bit, I don't know if he still practices, but he was called the king of torts. In other words, the king of suing. If I got myself an impartial witness, I think I was wasting my money. That is horrible, okay? That is horrible, and we cannot do things that support that conclusion, all right? And there will be attorneys. I've had attorneys. I'll never forget one attorney, and you could set it up any which way you want. There was this poor woman, and I can't remember the case, who had an untoward outcome, but I felt nothing was done wrong. Every other week, the attorney was calling me, don't you think you can say this, or don't you think you can say that? No is no. No is no. And in fact, you can report an attorney who is doing that to you. You have a very clear role. You have standards to abide by, and you can get in trouble, and you could be sued if you don't observe those standards. The cases often become a battle of the experts. All right, it really is. It comes down to that. So you have the expert on one side fighting against the expert on the other side, saying opposite things. And then this confounded jury is trying to figure out who's right. Something wrong happens on bypass that's fairly technical in nature. Some portion of the circuit breaks, whatever it is. Or there's some bubbles, and maybe they were minor, small little bubbles that you saw visually that you know in your heart of hearts didn't cause the patient's stroke. Okay? And you have one side arguing one way and the one side the other. How is a jury really to tell?
Who they think's who they
Right,
the most.
right. It's the one who advocates the best, who they can understand and who they like. Now, it's not a part of the process that's particularly attractive, but it's the way it is. So you want to be honest, but you also want to be approachable, and you want to be able to digest things for them. You want to be able to take all this complex chart in front of you that may be 1,000 pages, For your sake, you're lucky because perfusion is a very limited time. So you're not often dealing with voluminous stuff. You're dealing with the perfusion record and perhaps a little bit before and a little bit afterwards. All right, and you're looking at the conduct of the operation, and you're trying to decipher that, and you've got to figure out your most valuable role is being able to talk to the attorney and talk to the jury and talk to the opposing counsel and have them understand and see how compelling you are. Most of my cases have been dropped or settled because the opposing attorney found me very compelling. Because what is the opposing counsel? He's trying to trip you up. He's trying to see how easy it is to perturb you. He's trying to see if he can shake you. He's trying to see if you're going to talk too much. Talking too much, when you're on getting deposed, you shut up. You answer only the question asked. All right? If you want to elaborate too much, you get yourself into trouble. Anyway, if they see that you can solidly defend what you said, and you have a straight line from A to B to C to D, more than often than not, the opposing counsel who's spending his money to get you deposed, will say, we'll settle. Most of them will settle. Most of them don't drop. They'll just figure out some sum. If you're very compelling, your side will end up paying or receiving less, a better amount than the other side. But that's how it works. So the bias is that you're a hired gun. That's the way you're viewed by the profession, by your peers, and that's the way you're viewed by a lot of attorneys. I have an email. If an attorney emails me saying, we'd like you to consider doing this case, I have a set form that I respond back to them. I said, I expect this retainer, I make this much per hour of work, and I want to ensure that you understand that my fealty is to the truth. All right? I'm not going to, I don't even think about who I'm working for. I'm going to tell you the truth. And I think that's better for me, better for the patient, and better for you. And most of them understand that. I've said that right up front because I will not tolerate nonsense. And you got to be strong yourself. Key, and in most guidelines, for instance, the STS guidelines for cardiac surgeons, which pretty much are probably going to be adaptable to you guys. Honest, fair, and balanced. Fox News. Anyway, that's the key. And you always want to come across that way. You don't want to be a hired gun. You don't even want to think of yourself as a hired gun. And you will understand and know what the standard of care is. All right? Doesn't mean that you have to be a rocket scientist, but that you can define clearly in your mind. You get a case before you. So you're at the stage already that you're an expert witness, and you get a case. You've got this chart in front of you. What do I see that bothers me? And if it bothers me, is that something that I would push below the standard of care, or is it acceptable and just an untoward outcome? That's the bottom line. That was the whole point of the first 2 hours or so of what I've been talking to you about today. And it's hard. It's hard for me. And I'm not satisfied until I can say in a clear sentence what that standard of care is and why this surgeon went above or went below. Okay? And if you're on the plaintiff side, remember, you're the one who's got a point to prove. Defense is a little bit easier. Defense I particularly enjoy doing because I think, like I said, that most claims are not correct. They really are, what's the word for it? Frivolous, exactly. Thank you. And so, but you're on the defensive side. They've got to prove their argument. And if you can disassemble the argument, you can do really well for yourself. So, financially, you guys are all businessmen to some degree. This is good money. And everybody always asks, you even see when we discuss surgeons online in our clubs, what do you charge? And there are all sorts of rules of thumb. The brochure I have here is by a company called Seek, S-E-A-K. It's just the initials. Doesn't matter to me. Like I said, you go online, you'll find 15 different companies. I like their stuff, but this is from one of their books that I got some of this information. And this is all their consultants. So this is just not medical, it's across the board of all consultants. We're talking about engineers, industry, you name it. The range is in between 125 per hour to greater than 1,000 an hour. One of the things that I like for me is nowadays most surgeons are employed by the hospital, is it gives me 1099 income. And those who are familiar with tax law know that 1099 income can be very good because you can expense things as opposed to hoping that they'll turn out in deductions, not putting you on the alternative minimum tax, okay? So 1099 is good. So that's the income that you make, and typically what you'll do is you'll ask for a retainer, which is the legalese for a deposit, essentially. And the other advantages are, obviously, you're helping others. You're helping both sides. Remember, you're also telling that plaintiff's lawyer, sorry, you don't got a case. And you're keeping him from wasting his money. It's challenging, it's adventurous, it's a learning experience. You get to travel for court cases. I find it fun. I find it exhilarating. I like being in the battlefield. I enjoy it. I really, some people are miserable for this process, but I love it because to me, this is like, what's that channel that all the forensic cases, what is it?
Forensic Files.
Well, Forensic Files, but there's also the continuous channel that shows all those court cases. Anyway, you know what?
Court TV.
Court TV, all right. Anyway, it's like that. You're there and you are trying to expose the truth, and you're like a gladiator when the opposing counsel comes up. It ain't pretty sometimes, and you can learn harsh lessons along the way. But the idea is to stick to your guns, don't say too much, and know your stuff. All right? Disadvantages, not for the thin skin. I don't have to say this to perfusionists. They're probably the most thick-skinned people I know, for what they had to go through. Yeah. I don't know how you lasted that long, man. Anyway, it's really is. You've got to be able to withstand. If you don't like conflict, if you don't like being confronted, if you don't like having to defend your views, it's probably not for you to do. Now, I will tell you this. Some people restrict their practice to just chart review. And they don't get involved with the litigation at all. And you can make that practice. If that's your preference, listen, I'm happy to review. This is my rate. But if I find this to have validity, you'll have to find somebody else to do the deposition, et cetera. And that's fine as well. Hard work. Can be hard work. Can be very time consuming. Because really you're looking for a needle in a haystack sometimes. And the exhilarating part is when you find it. And that's a eureka moment. It's like doing detective work. Deadlines you have to deal with. The travel can be a plus or a minus. The one thing I didn't put there, I don't know what happened to it, is your relationship with your peers. Okay? And that's going to be a biggie. We're all in closed groups. We're all pretty small. Cardiac surgery is a small group, and so is perfusion. All right? And what do you do if you've been an expert or witness for a plaintiff and you've criticized somebody else and you run into them at Joe's conference? It can be uneasy. All right? That's why my preference is to do defensive work, because it's not fun, and that's why I'm also very. The plaintiff has to have an extremely strong case for me to agree to go ahead with it. But it's one of the things you got to think about. That doesn't mean you can't do it, but it just means you've got to decide ahead what kind of case you're going to take it. There are those that just say they're going to do defensive work, but I will tell you this: you have a lot more respect on the stand or in depositions if you're doing both sides, because it shows that you're not a hired gun, or that you have a more balanced approach as opposed to just always being for the defense. If you get hired by the defense, whether that's true or not, that's the implication. Well, how do you start? It's very easy. It doesn't require any startup costs at all, practically. All right? You beef up your CV. There are things that attorneys look for that I'm going to go over in a moment, but you really accurate CV. Don't have any inaccuracies. Not more so, not because of your marketing, because it can haunt you. When you go and give a deposition, they're going to have your CV. So don't confabulate. Don't make something more than what you are. because they will catch you. And on that one stupid thing can undermine your entire testimony. Because if you misrepresented this, what else are you misrepresenting? They will find it. So, accurate CV. About a third of people get a retention contract, and those are available online, where you send them a contract. I don't bother unless they want a contract. Okay? How much time I got?
20 minutes.
Okay. But contracts are available, very easy. They just basically say what you're getting as a retainer and what you're charged per hour. If you just are shooting them emails, you put an email, that's considered a contract. So you don't have to go through anything elaborate. They then go ahead and hire you by implication. That's a contract by inference. So it's done. The way you can be valuable and the best way you can grow your practice is to exceed their expectations. Really do the hard work, show them the pluses and minuses, gear them, guide the case, guide them, because they're helpless. They don't know what they're doing when it comes to the medicine. I'll often say, okay, listen, you need to have a radiologist read this x-ray. This is what I think, but you need a radiologist. And you guide them, you run the case. You end up steering the case for the most of the part after your involvement and helping them shape it to be accurate. You have to be able to defend your opinion, and you really need to write good reports. Organized, easy to read. Again, your goal is to make the other team say, hey, you know, we got a hot one here. We better think twice before we continue on with this. And obviously be outspoken. The vast majority of cases don't go anywhere. There's no trial. There's no trial. You know, you may get to deposition. I would tell you, in my experience, 90% don't make it past the review stage. The other 10% make it to the deposition. Of those that make it to deposition, half of them go on to be court cases. I can count the number of court cases I've done on half of one hand. Okay? So it's a few and far between. Most important aspect of you is, here's you. You have to be able to bridge the chasm. This is the big problem with what exists today. Right now, nobody knows how to talk to each other. The attorney knows how to talk to the layperson. They've been doing that their whole career. But the expert needs to know how to explain things to the attorney and guide them. The expert has to be able to communicate with the layperson jury. Okay, very important. And you've got to make it digestible, and it's easy. You know, you have to think of metaphors for what you do that'll make what you do very simple. If you think of a hose, a garden hose, whatever it is that you want to use, that's how you compel a jury. Somebody clamped a tube inadvertently, this is what happens. Well, what happens if you run a garden hose full out and you clamp it? You know, those kind of things you want to think out. And it's not hard to come up with those. And if you come up with those, that's going to make the difference. It's where you're going to shine. And juries happen to like people better who they understand. All this stuff about marketing is, I'm not going to dwell on. The things that I'm going to tell you about, social media is very important now. Attorneys like people who have more of an academic bent. If you don't have it, it's okay. But if you do, shine with that, lead with that, okay? If you're an academic facility, if you're here at Methodist, that's a real high volume center that is academic, is high on their list, okay? CCF, same wise. I mean, patients who, if they say that you're from this institution as opposed to Walla Walla, I hope nobody's from Walla Walla, but you know what I'm saying. It means a lot. In social media, if you have information to disseminate, you can start writing little columns or blurbs, or what do they call them? Blogs. Dealing with some of these issues. Take up an issue. Something, a perfusionist error. What you can do to, what does this problem consist of? And then you can have it posted on Facebook, Twitter, LinkedIn. You get my point. Easy advertising. It provides information. It gets propagated and gets you a name. Right? The more you're quoted, the more the people share what you have, the higher you'll come up on a search. A lot of the way that people find me a lot of times is from my YouTube videos. I have a YouTube site that's got 3 million hits. So when people search aortic dissection, if you go on Google and put aortic dissection, I'm probably on the first page there. That gets you. And I actually have a lecture on aortic dissection that I've given on that, and that gets me. They actually watch the whole lecture, and there's very little that's more compelling than that. Because if they watch you give a lecture, if you happen to be in that position, they see how you speak, how affable you are, how much you know. They're thinking jury all the time. Jury and how much you're going to intimidate the opposing counsel. There are also third-party groups that you can be a part, register on the sites. Many of them you don't have to pay for. You list yourself, you put a profile, and the lawyers pay to search the site to find an expert witness. Opposing counsel will try to embarrass you. They say, do you advertise? I say, hell yeah, of course. This is a business. I like doing this, but the only way I can get people is by people knowing who I am. Turn anything that's derogatory into a positive. Don't let them unnerve you. Don't let them. They want to make it sound like you're despicable. After all, which group is the one that does the more despicable stuff, right? The attorneys to begin with. So they know. But they will. They'll try to get you with that stuff. But this will get you in the ball game. And once you get started is when it starts to snowball. And you can limit yourself to whatever you want to do. Like I said, you can limit yourself just to review. You can limit yourself to just defensive work, whatever you want to do. The kind of things that I just discussed are what they look for. Pretty much it's intuitive. There's nothing really exciting about this, and how they locate. And a lot of them use the social media. And they Google, and they look for articles. If you're on a paper, put that on your CV. Share it on your social media. Whether it has to do with medicine or legal or something related. I'm going to skip all this stuff. So there's tension, and this is what I was speaking about earlier. You can be well compensated, it's a thrill, you're doing good, but this is the tough part that you have to be able to stomach. This is if you're deciding who to work for, all right, or who to be engaged by. So if you're going to do defendants only, you're going to avoid the discomfort of opposing your peers, but you limit your opportunities of work. If you do plaintiffs only, which I don't know anybody that does, anybody's got a predilection for doing that. But again, you get two bad ones. You both oppose peers and you limit your opportunities. And then if you do both, you get a more balanced approach. 90% of what I do is for defendants. That's the way I like it. Again, do not pay attention to which side you are working for. You are paid to make a determination of the standard of care and whether it was violated. Blinders. This can be uncertain at times, and the attorneys do appreciate the honesty. It's tough. What I wouldn't do is equivocate. You're there. You guys are working in the cardiac surgery field. This comes natural to cardiac surgeons. They make a decision and they stick with it, you know. And you know, you guys know, you can't stand pumping for people that vacillate all over the place. You know, they just drive you nuts.
Frequently wrong, never in.
Exactly. Shoot first. But be able to give a compelling case, but it's, well, I don't know. Because they're thinking while they're hearing, I don't know, then you're not going to make a very good expert for them. All right? Be clear on the standard of care. Be able to distinguish in your mind what's just an unfortunate event, a recognized complication of the procedure, even when everything is done correctly, as opposed to negligence where it was true substandard care that caused the harm. There are standards. Most of them are, you guys have it for Perfusion on perfusion.com or or AMSEC. Do they give you standards for expert witness? All right, probably not yet. People who are perfusionists, do you have to be, what are your qualifications to be a perfusionist? What do you have to be?
We have to like bananas.
And what else?
We have to not argue.
Come on, seriously, what do you have to be, if you're, when you go from being a student to a perfusionist, what do you
So
get?
Admission, I think at most schools now is at least a bachelor's, if I believe so.
That's to get into perfusion school.
To get into perfusion school, and then you're either going to go to a certificated program, which there's a few of those left. I think THI is one. There's bachelor's programs where you get a bachelor's from it, or master's program. There's even a PhD program, and then you have to take your boards exam in order to be able to practice.
Is everybody eligible for the boards who goes to any of these schools?
If it's an accredited school,
Accredited,
yes.
okay, okay.
You have to perform so many cases before you can sit.
Right, so you finish school, you go in apprentice or be in a student position under supervision, do the cases, is that, or are you already independent?
Yeah, you're independent.
You're independent at that stage. When do you have to be supervised? When you're a student? Okay.
Well,
So
but that's complicated, but I don't wanna get into those weeds too much. But here in Texas, where we're a licensed state, until you are board certified, you cannot work independently. So you would still be working in a supervisory capacity, not as a student, but as what would you call it? An intern position, whatever you would call it.
Board eligible.
But a board eligible position, right, but you cannot work independently.
How long are you board eligible for? Does it run out after a certain time?
1 year, I think.
1 year?
In California.
So if you don't pass it within that year, what
You have
happens?
2 years to pass. 2 years.
And what happens at 2 years?
And then you're no longer board eligible.
You can never, unless you go back
Unless
and,
you go back, right.
You don't have to, there's 2 exams a year and.
okay. Anyway, I don't need to learn all about how you guys get certified, but what the point is, whatever accreditation, you want to make sure you're there, right? Students couldn't be expert witnesses yet. I think if you are licensed and certified, you're going to be in the best position of all. If you're licensed and certified at a well-recognized center, that really puts you at the top of the heap. All right? Most need to be actively practicing, or at least practicing at the time of when the case occurred. Okay? If you're 5 years into retirement, usually you can't, certainly as a surgeon, you can't be an expert witness. All right? And, you know, there's a lot of what we call legal fictions that are out there. You know, this old legal fiction about how you have to practice like your peers did in the local area, that's no longer true, but sometimes that's perpetrated. Another legal fiction is, where was my train of thought? Another legal fiction is if you are, they'll come back to me in a second. I apologize, guys. My train of thought escaped me. But in any event, the better your qualifications, the better you're going to do from a standpoint of attracting attorneys. We talked about the fairness, honesty, and the balance. These are the 2 things you need to be distinguishing in your mind. We spoke about the first one, distinguishing between the negligence and a mishap that nobody could have prevented. And you have to distinguish between negligence and your own personal practice pattern. Okay? These are where people get into trouble and do the wrong thing. And never, we spoke about this at the beginning, never, if anybody offers you, you don't want contingency pay. That's a big ethical no-no. Making false, misleading, or deceptive statements exposes the practitioner to risks of criminal prosecution for perjury, civil suits for negligence, and puts your license at risk. Okay? Just be honest, be true. Be golden. You guys know where that movie is from? Be golden?
Outsiders?
Outsiders, very good. Anyway, you got to be true. All right, and you'll stay right. Don't get pushed into saying something you're not comfortable with. And if it comes to it, walk away. Say, listen, I'm happy to be your expert if I have the freedom of expressing my opinion. If you want somebody to say that, go find yourself somebody else. Okay? So this is again across all experts, medical and non-medical, just to give you an idea. So this is the rates that people charge. I have a different preference. I don't like all this complicated mess. I have 1 rate per hour, period. How do people figure out what rate they are? On the conservative side, people figure out what they make in a year and divide it by 2080, which is the number of hours in a 40-hour week times 52 weeks. So computing what your hour, as compared to hour, what you would make. Now, I think that that's cutting yourself short. Okay, this is cutting into your free time, which is worth more than your hour at work. Okay, my rule of thumb is you double it. Okay, and I haven't hurt for business as a result of it. All right, but it gives you a gauge. Think about what you're doing. If you want to do a quick figure in your head while we're talking now, divide your pay by 2,000. And that'll give you at least a lower amount at which you should be charging for this, okay? And that would be a very low rate. So people have, these are the mins, the max, the averages, case review, deposition, testifying in court. I have a straight hourly fee. I'm not gonna tell you what it is, but I have a straight hourly fee. And if I go testify, I don't tell them that they have to pay this number. What I say is, you are paying me for the time I am away from home. So I'm going to get my usual per hour up to a maximum of 12 hours a day. So if I have to be there in court testifying for 2 days, you're going to pay, and it's 2 full days, you're going to pay me for 20 hours of work. Okay? This makes it simple for everybody. But everybody's got their own little thing. Retainer, how much they need to put down up front. I usually put 3 hours worth of work as my retainer. I've been insisting on that a little bit more lately. I've noticed some attorneys, just like in any business, are laggards. So I'll have them give me the retainer first. When you're beginning, you're probably not going to want to push it, right? You want to build your practice. Just do the work, get paid, and move on. Okay? Mistakes to avoid. Don't underestimate yourself. Don't lowball yourself. Now, you're not really obligated, right? If you lowball yourself, you can raise your rates. That's no big deal. Your practice will grow by word of mouth from attorney to attorney. They will ask each other. I once got a referral of a case by the opposing attorney who liked the way I handled myself and then wanted me to review his case. You know, so any which opportunity there is, you can get it, and that's how you get it. Most of the things that I get right now are either people watching my YouTube stuff or getting referral from other lawyers. Depositions can be painful. How much time? 2 minutes? Okay. We already spoke about it. They're going to attack you. They're going to malign. Some of them will be nicey, sweetie. They're going to lull you into a false sense of security only to pull a rug out from under you. Stay alert. I actually am enthralled by it. I love that because it's kind of like, you know, dodgeball. You know, just kind of waiting for it and the pleasure of catching that ball. It really is. It's fun. If you approach this with the right confidence and mental state, this can be a lot of gratification. It really is when you've done a good job. If you don't know, don't guess. Don't guess. All right? That's outside of my practice. They will try to commit you to something. You don't look bad if you don't say it. I say it readily. Be prepared. You will be under the gun. Your attorney will try to make you look respectable. The opposing attorney will try to make you look like your opinion should not be trusted or that you do not know what you're talking about. Stay calm, poised, confident. So, the culmination of all of today, and I thank you for all your patience for sitting there that long for me. It is helpful to familiarize yourself with the law. It helps in envisioning how you can protect yourself if you ever are a defendant. All right, there are a whole bunch of perfusion literature and lectures on what you should do and shouldn't do and how you handle emergencies. That's not my job. My job is one thing happens, you recognize whether it's a problem or not. It helps you decide whether to take up expert witnessing as a side vocation. Above all else, be honest and scrupulous no matter what. So by understanding the law, you'll be a safer perfusionist, a better protected perfusionist, and you can have an interesting side vocation should you choose to do so. Thank you. Thanks for your patience.
Any questions while I get we play our game?
Sure. Go ahead.
So in your experience doing this, I don't know how long you've been doing this.
4 years. So not very long.
Of all the cases that come your way involving your expertise, how many of those or percentage of those involve perfusion likewise?
Very common. It's a very good question. okay? I am frequently asked to recommend a perfusionist, okay? And as you know, most of the cases we do, unless I'm asked about an off-pump case, pretty much you guys are integrally involved. The question is going to be about whether there's something that the perfusionist did wrong. That's what they're going to want to know, okay? Or if there's something the perfusionist has input about that I can't cover. Again, stay within your scope of practice. I'm not going to tell them what happens if you let the venous line empty, all the stuff that you guys know much better than I do. Because then I'll start to venture, I kind of know what happens, but I'm going to get myself out on a limb, and you don't want to do that, okay? And that's when we'll defer to you.
Okay, so-
But it's common.
So he's in room 1410 at the Marriott. Our time is up. I'm sorry, I gotta cut it. I'll turn the mic off. And